Good evening, everybody. We all are doing transaction with banks. We know we deposit the money in banks to get a return on the amount deposited by us. From where the bank is paying, the bank is earning by giving loan to others and returning us on our investment. What think about the things? If the bank is giving money and money is not returned, then what will happen to our money which is deposited after hard labor of life? To control that situation so that the borrower return the money gracefully, the Sarfaesi Act came into picture. So I am going to explain few of the issues related with Sarfaesi Act. We all know the object of law of insolvency is to see the property of an insolvent before he can squander it and run away. No doubt the debtor who comes to bank to take money is in need of money, but few are who return the money and has sufficient earnings, and but there may be few debtors who come with the mind of doing fraud with the bank. So if his property is secured one with the bank, then he bank can easily take the money. Earlier, civil suit was filed, and we all know it is the lengthy process to get the money returned through long, you can civil proceedings. Civil proceedings take long, lot of time, and it is not an easy job to get it in time. So to safeguard the interests of investors, the Sarfaesi Act came into picture. Now I will discuss in detail how it works. This act is a piece of one such legislation that focuses on strengthening the rights of the secured creditor against the defaulting debtors. It was enacted after the recommendation of so many committees and is an replacement of existing recovery of debts due to bank and financial institution Act 1993. Supreme Court in the matter of Mardia Chemical Limited versus Union of India declared the notable verdict of the constitutional validity of the Sarfaesi Act 2002. So in this landmark judgment, firstly the Sarfaesi Act 2 was challenged, which was declared constitutionally valid. And the second issue was discussed was when one goes into debt recovery tribunal without depositing 75% of the debt amount, which was compulsory at the time for appeal. And if the tribunal does not issue a stay order, the lender may sell the assets. This is why the issue decided that the lender will sell the assets. And moving a step further, the five-judge constitutional bench of the Supreme Court of India, in which Justice Indira Banerjee, Justice Beneath Saran, Justice M.I. Shah, Justice Nirda was and headed by Justice Arun Mishra. In one of the case was Pandurang Ganapati versus Vishwarao Sahakari Bank Limited. As we all know that earlier the cooperative banks were not covered under the Sarfaesi Act. What this judgment considered the cooperative banks to be recognized as banks under the Sarfaesi Act. So now these banks after that judgment can take the help of Sarfaesi Act 2002 and its authorities to get the money back so that non-performance assets are brought to the minimum. So we can say, no, this is applicable to cooperative banks. This judgment has caused the state and multi-state cooperative banks to seize and sell the assets of the defaulter to recover their dues, like any other banks under the Sarfaesi Act 2002. The main motive of the Wax Court is to remove the delays caused to the banks established by the cooperative societies due to the intervention of courts or summary procedure under the Cooperative Society Act as a process of recovery of loans due is an essential part of any banking system. Now, let us have the salient features of the Act. Under the Sarfaesi Act 2002, the creditors are conferred with the right to seize the secured assets. Now, the wording is secured assets. So, if the bank is having secured assets, only then the Sarfaesi Act will help. In unsecured assets, the Sarfaesi Act will do nothing. And the to sell off the same in order to recover dues promptly by passing the costly and very time-consuming legal process through courts is now avoided. This procedural law and retrospective effect established the concept of asset reconstruction company. Now ARC is doing better job. If the bank attach the property and then do auction, no one is available and no one applies for the auction, then there is ARC, Asset Reconstruction Company, to which bank sells out the property, which either converts it in its own way so that the bank's money is recovered. It will renovate or it will tie it up with others to get the things done for the safety of the bank's money. So the act is an effective tool for the recovery of NPA and is effective and against the secured loans only. Now coming to the salient features of the act, the first job it is doing is to securitize the financial assets. That is why it is known as securitization. Secondly, it funds the securitization. Third one is incorporate companies as SCO, securitization company, and RCO, reconstruction company. Another one object is to enforce security interest by the secured creditor without civil court intervention. It acts as an agent of the banks. It reconstructs the financial assets. There are so many jobs this is doing. It establishes central registry. We all know when we take loan from the bank takes a secured assets, which he got registered with the central registry. If that is not done by the banks, the Sarfaesi Act will do nothing. It will not come in the help of that banks. It prescribes the penalty for offences non-compliance of rules. Either it is by the bank or by the lender or by the debtor. For both, it prescribes penalties for offences that is for non-compliance of rules. Unlike many legislation, the Sarfaesi Act 2002 provides the bank the right to restore to action under Section 13(4) of the Act during the pendency of civil suit. The Act further ended the remedy of appeal against the actions relating to recovery of loans due. Now, when every act is passed, it has its own objectives and purposes. The Sarfaesi Act too has objective and purpose. The one key factor that has rapidly progressed India's economy is the efforts of the financial sector. Our country is progressing with the efforts of the financial sector. Despite the Indian banks and financial institutions keeping pace with international practices and norms, there was lacuna persisting in certain areas. The areas of concern included the lack of power with the financial institutions to recover the defaulting loans. If we talk about at international level, in other countries, the loan is easily recovered. But in our country, we are daily listening someone taken such a loan and now is out of the reach of the bank to recover the amount. So this act came for the safety or concern of the bank and it gives a time-bound result. So we can say the Sarfaesi Act 2002 was enacted after detailed perusal, enabling the banks and financial institutions to overcome the problem over liquidity, long-term assets, increasing NPA, and delay in recovery of loans. That is reconstruction of loans. Coming to the critical analysis of the Sarfaesi Act, the whole purpose of enactment of the Sarfaesi Act was to remove the time delay caused to the banks for the recovery of loans. It is considered as an essential function of the banking system, and an improper delay caused in such action cannot be encouraged. Thus, the banks wish to reduce their NPA through faster recovery. Since the previously enacted laws, namely Recovery of Debt due to Banks and Financial Institution Act 1993, failed to satisfy the agenda of enactment, leading to replacement. Hence, this Sarfaesi Act 2002 came into existence. Though initially few apprehensions over the utility of this legislation prevailed, as is happening with every act. Initial stage, it may not be effective. Later on, due to judicial pronouncements that give effective results. Similarly, in this case also, various judicial pronouncements have influenced a better understanding over the same. Now, discussing judicial pronouncements, one is Karnataka State Financial Corporation versus N. Narasimha. The Supreme Court has rightly highlighted the significance of constitutional right to property, guiding both the creditor and lender on the necessity of property mortgaged to the bank. The Supreme Court of India upheld the Sarfasi Act to be constitutionally valid, except for the provision under Section 72, subclause 2 of the Act, as it was altered by the Article 14 of the Indian Constitution. So, the Sarfasi Act 2002 was challenged and it was held to be constitutionally valid, except this provision under Section 17, subclause 2. The Ministry of Finance, by notification dated 24th February 2020, considered non-banking financial companies having assets worth rupee 100 crore and above to be entitled for enforcement of security interest in secure debts of rupee 50 lakh and above, similar to that of financial institution for the purpose of the Sarfaesi Act. Now, cooperative banks of Punjab, Maharashtra, and other cooperative banks expose the vulnerable nature of the cooperative banks. With regard to this, in the matter of Pandurang Ganapati versus Vishwarao Patil, Sahkari Bank, the Supreme Court of India has established the following outcome. In the judgment, the following directions were given by the Supreme Court. It said that the cooperative banks established under both the state and multi-state level cooperative societies are recognized under Section 2, Subclause 1, Subclause E of the Sarfaesi Act. That is, they are known as banks. Thus, allowing the secured character to take possession of the assets of defaulting borrowers within 60 days from deemed for payment, as per Section 13 of the Act. Cooperative banks are bound by the provision of the legislations that are relatable to entry 45 of the list 1 of the 7th schedule, such as Banking Regulation Act 1949 and other legislations that the banks are generally governed as under the Reserve Bank of India. When the banks are doing all such formalities as desired by the Reserve Bank of India Act, thus the cooperative bank are considered under the definition of banking. That's why Sarfaesi Act is on their safety. Again, the activities of the cooperative banks are explained in entry 45 and 38 of the list 1 of the 7th schedule and are covered within the meaning of banking company as defined under Section 5 Subclause C, read with Section 56 Subclause A of the Banking Regulation Act 1949. So, I mean to say, now they are covered under the definition of banking. So, Sarfaesi Act is enforceable for the cooperative societies also. The process of incorporation, regulation, and binding up of cooperative banks are also dealt under entry 32 of the list 2 of the 7th schedule. It again confirms that the cooperative banks come under the definition of banking as defined under the Sarfaesi Act. The power of the parliament to enact law in order to provide the banks with the recovery procedure for speedy recovery of dues without the court's intervention was upheld through the judgment. Thereby, the Apex Court upheld the 2003 government notification, which allowed the bank to recover the dues from the defaulters through the prescribed recovery procedure under Section 13 of the Sarfaesi Act without the intervention of the court or the tribunal. After such a judicial announcements and banking systems phenomena, specifically cooperative banks, when they have been declared through judicial pronouncements that they come under the class bank business, so the Sarfaesi Act will come to their safety to recover the loan, as it is quite easy within the time frame to recover the loan from defaulters under this act. So my conclusion is various developments in Sarfaesi Act is witnessed in the recent years to fulfill the criteria of legislation. The judiciary has always helped to keep the doubts away from interpretation of legislative provisions. The new development in the scope of Sarfaesi Act 2002 is the necessity that has been rightly upheld by the Supreme Court. The Sarfaesi Act 2002 being an important act for the betterment of country's economy, widening its scope is felt to be an essential step to strengthen the financial institution of the country. So the judgments have saved so many cooperative banks from being put under liquidation or closed. So, friends, I had performed my duty. Whatsoever knowledge I was having, I have shared with you. Now it's your duty to share with others and like this video so that may give me motivation in future to make more videos. Thanks. Jai Hind.